Members, it is about time we have attained the quorum. Item number 1, confirmation of the minutes of the third meeting held on October 24th. Can I take the minutes as confirmed? Nothing under matters arising. Business arising from previous council meetings. Legal Service Division report on subsidiary legislation, gazetted on October the 24th and tabled in council on October 29th. Legal advisor, please. Chairman, thank you. Chairman, please refer to paper LS7, stroke 14 to 15. There are 8 items there. The first 4 have to do with fee revision, mines, dangerous goods, and storage fees and charges. There will be upward adjustment. And also service fees under waterworks regulation will see some increase. The rate of increase is set out in the paper, 4.6 to 20.8%. According to the administration, this is intended to achieve cost recovery and to avoid any sudden steep increase. The come into operation on January the 1st next year. Subcommittee needed? No? All right, legal advisor, please. Chairman, the next 3 are intended to implement Basel III requirements. For Basel III requirements in 2012, the Council enacted the Banking Amendment Ordinance 2012. There are 2 phases of implementation. The SFST under LN 127 designates January 1st, 2015 for the implementation of the unimplemented measures. And it is required that there has to be capital. That there should be certain capital, and there is also the liquidity requirements to replace the existing liquidity ratio. According to the administration, the trade has been consulted by the Hong Kong MA. There are certain statutory bodies that have been consulted, and they gained the support of the people concerned, and it was taken to the FA panel in October this year. Some members expressed concerns about the fact that in order to measure up to the Basel III requirements, that there are certain small-time businesses that will incur additional costs, and they are also concerned by the implementation date. LN 128, 129, we have set out our views in the paper. We are prepared to file further reports. Subcommittee? No? Legal advisor, please. Chairman, the last one is a notice under Antiquities and Monuments Ordinance. The notice declares the following places to be historical buildings: Linfa Temple, Hong Shing Temple, and Hao Wang Temple, and they will be protected under the Antiquities and Monuments Ordinance. It comes into effect on 24th of October 2014. Subcommittee? No? Well, let's move on to further business for Council meeting November 5th. The outstanding business will be transferred to the November 5th meeting. Mr. Che and Mr. Paul Che, Ms. Elizabeth Quat have replaced their questions. Business for Council meeting of November 12th. There are 22 questions, 6 are written, the rest are written. Bill's first reading, and no notice there. Bill, resumption of debate on second reading, Competition Amendment Bill 2014. No government motion there. Members' motions. Since on the 29th of October, we couldn't handle the non-binding motions, and the motions that are outstanding will be transferred to this meeting. There are 3 pieces of subsidiary legislation that have been made available to members. Just a reminder that for amendments, for notice to speak, members are supposed to give notice to the Secretary on the 4th of November, Thursday. Reports of bills, committees, and subcommittees. Report of the Subcommittee on Road Traffic Amendment Ordinance 2012. Dr. Lo Wai Kwok. Chairman, thank you. The Road Traffic Amendment Ordinance 2012 commencement notice provides that applicants of PLB driving license will have to attend and complete pre-service course before driving license would be issued. Under the RTA Ordinance 2012 commencement notice, the 1st of June 2015 will be the commencement date. The subcommittee held 3 meetings, including 1 public hearing. The committee is in general supportive of the introduction of a pre-service course to enhance PLB safety, but we understand that the trade is experiencing difficulties in recruiting drivers. The introduction of this requirement means a higher entry threshold. This would aggravate operating difficulties. The members urged the administration to postpone the commencement date. The administration said in response that the motion will be moved to make amendments to postpone the commencement date to the 1st of June 2016. However, since at the council meeting on 22nd of October, the date on which the scrutiny period expired, we could not seek an extension to the scrutiny period. The scrutiny period has come and gone, and neither members nor the government can make an amendment to the notice, and therefore the commencement date will remain the 1st of June 2015. All the details are set out in the written report. Thank you. Next, report of the Subcommittee on Rules of High Court, Amendment Number 2 Rules 2014 and Rules of District Court Amendment Rules 2014. Mr. Dennis Kwok. Chairman, thank you. The scrutiny period could not be extended on the 22nd of October. The scrutiny period has already expired. This will go into effect on the 1st of December 2014. We have liaised with the JS and the DOJ. We have 1 meeting. Members did discuss the interpleader issue. Under the existing arrangement, the interpleader issue with parties concerned and without parties concerned, there will be different appeal channels. They will be lodged with the master. It is a waste of time and also legal costs for appeal going through a fresh hearing in the CFL again, and some members feel that since the quality of the hearing by the judges and the master may vary, but as the time goes on, the quality would remain pretty much the same. Members are in support of the amendments. All the details are set out in the paper. All right, next, proposed extension of the period of work of subcommittees on policy issues. There are 3 subcommittees that are seeking extension for 2014-15, and they are the Joint Subcommittee to monitor the implementation of the WKCD under the HAP and also the DEVP. The second one is the Subcommittee on Health Protection Scheme under the HSP. The third one is the Subcommittee on Matters Relating to Railways under the TP. There are 7 SCs scrutinizing policy that in action. There are no committees in the waiting list. We agreed that all the principles regarding the activation, operation, extension period of work subcommittee has been discussed, and all the details are set out in the paper. And members are requested to consider approving the extension till the 30th of September 2015. All right, all agreed. Position of bills, committees and subcommittees. As of the 30th of October, 16 BCs and 10 SCs and 9 SEs to do with the policies that are in operation. There is 1 on the waiting list. Next, proposal of Ms. Sid Ho and Mr. Kenneth Leung to seek the Council's authorization for the appointment of a select committee to inquire into whether Chief Executive Mr. Leung Chun-ying has contravened Article 47 of the Basic Law and issues relating to possible conflict of interests arising from Mr. Leung's alleged holding of shares and in DTZ Japan.
Ms. Sid Ho, thank you, Mr. Chairman. Well, for this letter, 2 weeks ago, Ms. Claudia Mo and Mr. Dennis Kwok would like to follow up on the question of conflict of interest in relation to the acquisition of DTZ, and this is sort of a extension of that matter. On that occasion, we talked about the 50 million Hong Kong dollars involved. The contract is still valid within the term of office of the CE, and the outstanding payment was only collected after he has assumed the office, so there's serious conflict of interest. There's another part that is through an overseas registered company. C.Y. Leung is still hiding the 30% shareholding in DTZ Japan. At the time of taking up the office, he only declared the details about the overseas registered company. DTZ Japan is still having a lot of business dealings with a Hong Kong company that is HKR International, and it's a major shareholder, HATV, and it is holding a lot of land interest on Lantau. So, in fact, according to the contract, in 7 years' time, within 7 years' time, he can still sell the 30% shareholding of DTZ. And then the value would go up together with the increases in the share prices. So in relation to the 30% of the shares, and with the share prices going up all the time, that vis-a-vis his status as the CEO of Hong Kong and dealing with the policies in relation to like free TV license policies and Lantau development policies, we want to know whether that would also have a bearing on things related to the companies involved. He can still sell the 30% of the shares. The interest is still ongoing. So I want to know, at the time of taking up the office, whether he himself made a declaration to the Chief Justice in relation to this asset, in relation to this interest. This is not known to us. Mr. Chairman, for a chief executive to assume office and yet he is still having another commercial contract that's outrageous, and the interest is still there, the conflict of interest is still there. So all the more we need to have a very detailed examination as to the relationship. Therefore, together with Kenneth Leung, I have co-signed this letter, hoping that we get the agreement of the House Committee so that you, sir, on behalf of us, you would move a motion at the electrical meeting so as to invoke the LCP&P ordinance to carry out an investigation. Mr. Leung Kwok Hong, 2 minutes. I did ask a question about the BVI company of Mr. C.Y. Leung. I asked many questions many times. I can't ask him face to face. It's up to somebody else to expose it. And I tried to ask for an answer twice. I had to hurl objects at him, and still he would not answer my questions. Now, he is the CE. He owns the shares. We don't know to whom he will sell the shares, and the share value can increase. We don't know whether he has got any deal with Raisin Cha. Now, James Tian is not here. I don't think C.Y. Leung is not suitable for the post for the CE. Now, I'm not a member of the CPPCC, but I agree that he's not suitable as a post holder of the CE. As Mr. Wong Kwok Kin has rightly pointed out, we don't know, and that's why we want to investigate into the matter. Now, Tam Yu Chung, you better swallow everything you have said here. When there is a doubt, then we have to investigate. If you don't, then you better just go home and have tea. Now, times have changed, and you've also changed. Now, on 5 occasions, I asked him. On 2 occasions during a Q&A session, and I hurled objects at him. And then I was told that in Hong Kong, all the middle class would open a PVI company to conduct business, and there's no question of tax evasion. Well, I think Tam Yu Chung, you should withdraw your remarks. You are supporting him blindly. You are spoiling him. Do you have a share in it? Do you need to declare interest? All of you. Dr. Helena Wong. Mr. Chairman, on behalf of the 6 members of the Democratic Party, I would like to say that we support the proposal or request of Sid Ho and Kenneth Leung so as to look into the question, that is whether he is contravening the relevant provisions of the Basic Law. For the pro-establishment camp, please do not repeat the same old point. That is, the PNP is the ultimate weapon and shouldn't be invoked lightly. Just recently, you tried to invoke that to investigate into the Occupy Central movement. So if we are to wield this assault, of course we shouldn't be using it against the citizens. We should use it to investigate into the affairs of the topmost official. Mr. Chairman, I think you need to declare, and other CPPCC members should also declare, that is, whether you shouldn't vote on this matter. This is because just yesterday, or the day before yesterday, this already happened. James Tian forgot his membership. Now, let me just remind you, now, in relation to a thorough investigation into C.Y. Leung, if you think that this goes against your role as a CPPCC member and therefore you would object to the use of the PNP to probe into it, then it means that you are speaking on behalf of the CPG rather than an electoral member. So, Chair, you better clarify whether you are chairing the meeting as a CPPCC member or a lawmaker and as the chair of the House Committee. Albert Chen, she's asking you a question. You better answer her question. there's no need for me to answer the question. Albert Chan, it's a privilege. So you can choose whatever hat you wear, CPPCC member or lawmaker or an ordinary citizen. It's up to you to choose. Well, I'm really concerned. The patriotic camp, the pro-establishment camp, have been talking about their concerns about the external influence. I think we need to be patriotic. We need to be concerned about Hong Kong. And we want to find out whether there are any relationships between Hong Kong and the external forces, explicitly or implicitly. Now, a $50 million contract is blatant. It is a collusion with the outside forces. Well, somebody has described it as a golden handshake. After finish with something, you get a golden handshake. Well, I would rather have numerous handshakes in this way. Mr. Chairman, whether it is lawful, whether it is in compliance with the procedures, I think that's secondary. But under one country, two systems, we have a special administrative region, and we have the most senior official appointed by the CPG, and just before he took office, he signed a contract of $50 million. I just wondered if a overseas intelligence agency is involved, whether he's a double spy. Maybe the CPG asked him to sign a contract, establish a relationship so as to gather intelligence. It's up to the CPG to clarify. I want to have an investigation. It is simply because I want to know whether external forces are involved, and therefore the pro-establishment camp should not object to it unless they're saying that because he's a double spy. Dennis Kwok, Albert Chan, it's not your time to speak. You don't need to clarify. If you don't shut up. Dennis Kwok. Mr. Chairman, we have been interested in this matter right from the beginning because it has raised many questions. Other than his shareholding in DTZ Japan and declaration of interest, in fact, the other day I directed the question at the CS4A, though I couldn't direct the question personally at the CE. When he signed the contract, he was still the head of the DTZ Asia. And then for the $50 million reward, I think this is virtually an exchange for his support for the taking over of DTZ by UGL. Now, the company involved has already issued a declaration saying that it was not in the picture. And then RSB also said so. So DTZ probably didn't know about it. Now, for CY Leung to sign this private contract and collected $50 million, I would like to know whether it was known to the board of directors, whether it had got any authorization. This is the key to the question. CY Leung hasn't come out to clarify this point, and in fact, it may be a contract that contravenes the acceptance of advantage or interest. Now, it is a major issue if we don't invoke the PNP for this purpose. When are we going to use it, and what is it for? Don't forget that as far as dealing with corruption is concerned, the CPG is going all out to do it. If we don't probe into the CE's business, I don't think we are being fair to the CPG. Mr. Yip Kin Yun, this is the second time today that we talk about an investigation under the PNP. I think we should be consistent in our spirit. That is, for this piece of ordinance, we should be aiming at the executive. Now, if we can't deal with it through the ordinary channels, then we should invoke the LCPNP ordinance. Just now, Mr. Dennis Kwok said that he would like to know whether there was an unlawful acceptance of advantage, whether it was a case of a part-time job. Now, if it is at the level of the CE, then we should know about the facts. We want to know the truth. So far, Mr. Dennis Kwok can at most be directing the question at CS4A. He couldn't ask the CE himself. It is only when we ask the CE himself can we seek an answer. Therefore, for us to invoke the LCPMP ordinance to carry out an investigation, I think it is necessary. It is only then can we carry out the investigation. We have substantiated the request. It is most extraordinary. A legislature won't resort to this lightly. It is exactly because of the seriousness of the nature that we have to do so. Therefore, I support Sid Ho and Kenneth Leung's request. I think we must do this, otherwise we are not being fair to the electors. They have entrusted with us the job to be dedicated in our work in monitoring the executive, so that the executive won't go astray and won't find itself being dragged down by many problems. Any other members wishing to ask questions in the first round? Mr. Lee. Mr. Chairman, the DAB is against the request to invoke the powers and privileges to probe into the C's case. Last time, a similar request was vetoed, and last Wednesday, for the same topic, a question was asked, and the CS4A gave a clear answer. For the coming Wednesday sitting, and in fact, we're going to have another opportunity to allow each member to speak up to 15 minutes as to whether there is any conflict of interest. Now, for the same issue, we are asked to vote on this matter. I think everybody knows clearly it is a politically motivated issue. They're trying to deal a blow to the credibility of the CE. I'm having the floor, Mr. Chairman. Leung Kwok Hong, is not your time to speak. After this was exposed, the ICAC received a complaint, and maybe ICAC is now carrying out an investigation. Members just ignored the fact that the ICAC had already received a complaint. Now they are trying to take it to the extreme. They are trying to vilify him by saying that the contract shows that he's involved in external forces.
I remember we discussed the shady sources of funding this morning. This is a proper commercial contract. It's got nothing to do with the shady funding. We are against invoking the PNP. Mr. Leung Kwok Hong, this is the last warning for you. You are speaking out of turn. I will send you out of the chamber. Mr. Abraham Sheikh. Chairman, I'm looking at the Basic Law, Article 47. Article 47, there are two paragraphs there. The first one has to do with a person of integrity, and also whether he's dedicated to his or her duties. I think this should be left to history. As regards integrity, he hasn't done anything for any company. And also, in November 2010, he has already resigned from the DTZ. He was the head of the Asia-Pacific region till December. Under Article 47 of the Basic Law, he has made it very clear that there is nothing wrong involved. Now, some members had said that the contract has certain conditions, for his service. We don't have the copy of the contract. And also in the contract itself, he has not done anything in accordance with the contractual terms for these 2 years. I think we have to look at the actual situation. We have to look at the terms of the contract and see whether he has done anything. We cannot say that the contract has this obligation and has to do it, but he hasn't done anything. He said that he is not going to do it. Now, Article 47 is very, very clear. Mr. Shek, your time is up. Mr. Lee Chao-yen. Chairman, Mr. Starry Lee said that we do have a political motive. Our political motive is very clear, and that is the chief executive of the Hong Kong SAR will measure up to the basic law requirement that he is someone of integrity. Now, this is a political motive which is above board. Now, when the DAB invokes the trump card, they would will this tool on the civic society. This morning it was a case in point because they were suggesting that investigation be conducted into the civic society. I think this PNP trump card should be used to monitor the government, and they never use it for that. Mr. Shek is referring to the UGL. Now, we're not talking about UGL this time around. This motion is basically about C.Y. Leung's shareholdings in DTZ Japan and his involvement with the Payson Cha. Now, in fact, C.Y. Leung has some shareholdings in DTZ Japan, and this DTZ Japan also helps Hong Kong Resort to deal with the real estate issues. Now, when DTZ is helping Hong Kong Resort in the real estate in Japan, so there would be benefits arising from it, and C.Y. Leung controls 30% of the shareholdings. Mrs. Carrie Lam refused to answer the question as to whether he made the declaration. When discussions took place regarding Hong Kong Resort, there was no declaration. We have to find out whether there is anything wrong with it. Mr. Fernando Cheung, well, this is patently intrusion by foreign forces. Now, this is an engineering firm from Australia. The chief executive admitted that he collected $50 million from this foreign company, and he is the chief executive of the Hong Kong SAR. The chief executive in Hong Kong is in charge of a broad portfolio. Ms. Sid Ho mentioned a moment ago that through the BVI company, he is in possession of the DTZ Japan, and this company has dealings with Hong Kong Resort, and Hong Kong Resort has dealings with the Asia Television of Hong Kong. The chief executive is in control of the MTRC because 70% of the shareholdings belong to the government. The board members are appointed by the chief executive himself. MTRC has dealings with the UGL. There are commercial dealings. I mean, the relationship, the ties are so convoluted. A fortnight ago, the SCMP exposed that the chief executive, C.Y. Leung, not only wanted the $50 million, he wanted £3 million in addition, as if this was not enough. Now, these foreign forces are intruding into Hong Kong. I'm not sure how much advantage they have gained out of Hong Kong. Now, you're really bent on investigating foreign forces. Why don't you carry out an investigation? The chief executive is under the thumbs of these foreign forces. Ms. Wong Tong, I think members tend to put their foot in the mouth a lot. But what Ms. Sarah Lee and Mr. Sheikh are talking about is not what we are discussing. Now, we are discussing the 30% shareholdings by the chief executive in this company. This is a direct pecuniary interest. Let's not talk about the foreign forces. Let's brush that aside. Under the commercial principle, Hong Kong Resort is a client of DTZ. Commercially, this is their boss. Now, this is C.Y. Leung's boss. And this company owns the shareholdings of ATV in Hong Kong. And it's very pure and simple from a commercial point of view. For Hong Kong television license to be granted, it might lead to the collapse of ATV. It might suspend ATV's license. Would that enrage the ATV, the boss? And this might affect the values of the shares of that company. Now, these are commercial interests, and I hope that members will consider all these logical links between these entities. If he has direct pecuniary interests, should he be put in charge of the licensing issue for TV? And second, does he have to come clean and tell the people of Hong Kong? Shouldn't he have made a declaration to the Chief Justice? Shouldn't we be concerned about all of this as councillors ourselves? Now, we are concerned that the chief executive has a boss behind him, and I think it is only right and proper that we are concerned about this. UGL, we have to conduct investigation, that's for sure, but this issue is just as important that warrants an investigation. Mr. Raymond Chan, Chairman, I support Ms. Sit Ho's proposal to investigate C.Y. Leung's suspected shareholdings in DTZ Japan and all the conflict of interest. On Wednesday, Mr. Albert Ho put an oral question. Mrs. Carrie Lam said in reply that regarding Mr. Ho's question after consulting the CE's office, the reply is as follows, meaning that Carrie Lam is merely a megaphone. He is merely conveying the message. She's saying nothing more. Dr. N. Chung put a question that can we find out whether C.Y. Leung has provided the service after receiving the payment? Carrie Lam said that she wouldn't be in a position to know the assets of C.Y. Leung. She doubts whether C.Y. Leung's wife would know as much. So Carrie Lam couldn't answer on behalf of C.Y. Leung whether he has done anything in this regard. C.Y. Leung is supposed to face questions here, but in the heat of the moment, he cited certain reasons, like he couldn't get access by car, and he chose not to come here, and he is dragging his feet and hoping that the issue will die down, will fade. That will not happen. LegCo will certainly pursue the matter. I hope that the pro-establishment members would not vote later on, because if you cast a vote in favor, then your CCPCC membership will be at stake. If you cast the other way around, then you may be accused of blindly voting. Ms. Helen Wong has got a point. In order to save your CPPCC seat, you may just cast a no vote regardless. Does any other member wish to speak? Mr. Albert Ho, Chairman. I think the scope of this investigation is very clear. The objective is very, very clear. We are basically looking at the fact that whether the chief executive is acting in accordance with Article 47 of the Basic Law. Article 47 provides for the declaration of assets to the Chief Justice. The provision doesn't mention what the Chief Justice can do. Now, there is a phrase uttered by Carrie Lam which was jarring to my ear. Maybe she worked for C.Y. Leung for too long. She's very good at sophistry. She said that this effectively she's saying that there is something which is not disclosed. I think she's talking about the UGL, and she said that this is nothing secret. It's just that it's not disclosed. Now, if this is not disclosed, then it must be something secretive. If you want to have the perception of having integrity, you have to be seen to be having integrity. So with regard to the declaration of assets, there is no reason why it has to be kept under wraps. Has she given us the clear disclosure? And she said that there is no definition regarding assets. So it is open to interpretation here. I think obviously there was no declaration. The $50 million, he probably hasn't collected all, but he has not made the declaration. And when he received the money, he hasn't made the declaration. I think we have to show this to the public. Mr. Wong Kuo-heng, Chairman, I am against the idea of invoking the PNP to conduct a probe, because the whole thing has to do with the political situation. The pan-Democrat members and parties can exercise the power, but why did they have to do so? Why is it that they are doing this again and again and again? Ms. Darley has made it very clear just a moment ago. The purpose of them doing so is to unseat C.Y. Leung, to topple him. And it has to do with the political situation in Hong Kong. It has everything to do with this.
This morning, Chairman, you try to invoke the PNP so as to look into the organization, the resources, and the influence behind the scene of this entire movement. But then as a result of the opposition by the opposing camp, it was not endorsed. Now they try it again. They try to achieve the political objective of unseating C.Y. Leung. So we can see their role, we can see their interests, and they are all related. They themselves are using shady resources, and for more than 10 hours during the debate, they did not afford any explanation. Now, today, they try to invoke the PNP. So in the eyes of the public, it is a matter of being self-contradictory. Anybody else wishing to speak? Claudia Mo. I speak in support of this motion for 3 reasons. First of all, the people of Hong Kong should be very worried about infiltration of external forces into the C's office. And then when we come to the personal assets of C.Y. Leung, and then you can see that it is very difficult for the CS4A to answer the question on his behalf. I think it can be sure that she just tried to rely on the information coming from the C's office. She tried to cite from a paper telling us that, hey, this one was in the picture, the other was also in the know. It was all about the knowledge about the intention of having a secret contract. Now, Carrie Lam said that it's not secret, but then it was not in the public domain. Now, he's the CE. We have asked for it being made public, and he has refused it. And that's the reason why we say that it is most secretive. And then Ronnie Tong has said something which can most represent what I wish to say. For DTZ Japan, C.Y. Leung has got shares in DTZ Japan. and one of his clients, in other words, one of his bosses is HKR International. And then you know about the intertwining of the ties. That is, we want to know in relation to the free TV licensing. We want to know about the role to be played and was played by CY Leung. So we must probe into the matter. And Leung, Mr. Chairman, say for example, if you have got a staff member, he is moonlighting, and then as the boss, of course, you are entitled to know about it. Now, if you say that I don't mind, if you want to have moonlighting, then it's fine. But it doesn't mean that you are not entitled to the knowledge. And that's as simple as that in this case. I don't know whether CY Leung would regard us as his boss, or rather CCP is his boss, but the two do not conflict with each other. I think you can have two bosses, one the CCP administration in Beijing, the other being the Hong Kong people. Both bosses have the right to know the following. That is, as colleagues have already said, when it came to the TV licensing, whether he has sort of made it easy for his third boss, that is HKR. So it is as simple as that. On the one hand, CY Leung pledged allegiance to the CPG, to the Hong Kong people, when he assumed office, and then we found that in fact he had got a third boss called HKR. Now we want to invoke the LCPPP PNP ordinance, so that we want to find out when he discharges his duties as the CE, whether his secret part-time job has affected his official position, that is the CE. So it is very simple, and I don't think we need to spend too much time to debate on this issue. I think when the matter is put to the vote, then the people of Hong Kong know who's safeguarding their rights as the boss of the CE. Who else would like to speak? If not, then I would like to draw a line here, and two members would like to speak for a second time. Helena Wong, 1 minute. Mr. Chairman, I raised a question, and in fact we have got many members of the CPPCC and National People's Congress deputies, including you, sir. So when the matter is to be voted on, I hope the legal advisor can give us advice. That is for LegCo members who are also members of the CPPCC, when they take part in the voting, will it be involving any conflict of interest? From the James Chen saga, we can see that members of the CPPCC do not have free will. So on this matter, when there is a probe into CY Leung, it is toppling CY Leung, and it is against the rules. Can the legal advisor clarify on this point? Abraham Sheikh. Let me respond to Ronnie Tong's point. I can understand his point, but then for Basic Law Article 47, it reflects the spirit of the separation of the powers. Now, the CE is not declaring his assets to the legislature, rather to the CJ. Now, he has got this duty to declare to the CJ. If he commits any mistake, then it's up to the CJ to take it up. So let's go back to Article 47. I'm not being ignorant, but I think I know what Article 47 is about. I know about the spirit of Article 47. This is all about check and balance under the separation of three powers. This morning you opposed to Andrew's motion, but then for PNP, it's not about commercial acts, it's about the executive, it's about the government. In this case, if there is a mistake, had there been a mistake, the CJ has got the duty to tell the public. Mr. Leung Sing. Now, I think I would like to draw a line here. Reference has been made about the NPC deputies as well as the CPPCC members. Now, in fact, they have been elected in accordance with the relevant rules and laws. So if you easily drag in the question of CPPCC and NPC membership, then it will cause chaos in our public affairs. I think it's better for us to talk about whether you have received any money. Now, in the past, some members have said that they are pocketing some money on behalf of the political parties, or it is said that the money is in relation to elections. It is all very complicated. If those who have received money should also make a declaration, then what about those suspected receipt of money? I think they should also declare, and then equally they should refrain from voting. Those who are in favor of Sit Ho and Kenneth Leung's. What about my question? I asked the legal advisor to give advice. Yes, I'm going to deal with it in a moment. Sit Ho, 2 minutes. I'll give you 2 minutes to sum up. Yes, you need to give me the floor to give a reply. Now, I hope that the pro-establishment camp won't blindly support Xu Caihou, Zhou Yongkang, have their cases looked into. Why can't we look into the case of the CE? So you shouldn't support CPG blindly. I think it's not a matter of opposing PMP. We better call you the royalists. You are not the pro-establishment camp. Now, you dare not take up the corruption involving the senior officials, though you would go harsh against the grassroots. Now, for the CE, he assumed office, but then it's most abnormal for him to have an ongoing commercial contract. How come that he could collect the outstanding payment even after assuming office? Now, Wang Kwok-hing is saying that we are trying time and again to do a blow against the CE. Yes, we've got many other livelihood issues like rent control or universal retirement, etc. But unfortunately, we have scandals one after another implicating the CE. So we must look into his case. Now, for the royalists, don't try to be so blindly supportive of him. Regina Yip is an EXCO member. She chooses to remain silent. Jeffrey Lam is even absent from this chamber. So the conflict of interest is just too blatant. I think the public should watch the voting outcome. Please try to look at the principles that members hold on to when they vote. I don't expect this to be endorsed, but we will go to the electoral meeting. Legal advisor. Mr. Chairman, for motions or issues discussed by LegCo members as to whether there is any conflict of interest is always up to individual members to make their own judgment. I don't think I've got anything else to say to provide further assistance. Those who are in favor of Sit Ho and Kenneth Leung's. Well, if the legal advisor cannot advise us on this, then I thought Leung Sing should go on with what he was trying to say. Now, for CPPCC members and NPC members who are also lawmakers, please tell us whether you have any pecuniary interest or non-pecuniary interest. According to 83A of the Rules of Procedures, members should not move any motions or amendments in business in which he has got pecuniary interest or vote in it unless he declares interest. But it doesn't actually as to whether a member has got pecuniary interest, it has got direct or indirect interest, is up to members to make their own judgment. Members who are in favor of Sit Ho and Kenneth Leung's motion. Sit Ho claims a division. The bell will be rung for 5 minutes.
現在開始表決。
Please proceed to vote. Before voting is brought to a close, please check your votes. If there are no questions, I'll display the results. 52 present, 24, 31 against, no abstention. The proposal is voted down. I've got nothing under AOB. Meeting adjourned.